So one of the most important things that you can do as a landlord is understand the kinds of notices that you should be delivering and when it's appropriate to deliver them. Today we're talking all about the right notice and the right time to send it. Let's get started. One of the most important pieces of evidence in any case between a landlord and a tenant is going to be the notice that was sent. The document that you send to your tenant is an important part of your ability to win your case, whether this is an eviction, a matter of breach, whether they have a claim against you. You want to make sure that your notices are always in accordance with the law, in accordance with the lease, and are delivered properly. So many times landlords end up losing cases and have to end up refiling or end up paying damages to their tenant because of a defect in their notices. Today I want to make sure that the notices that you are sending make sense for your court case and actually get the job done. So the first notice you have to consider is a notice of default. Your notice of default informs the tenant that they have committed some violation of the lease. Unfortunately, many landlords never issue a notice of default. They'll come to my office and say, Ernie, I have had this tenant do X, Y, and Z over and over and over again, but they have no evidence that they ever issued a notice of default to that tenant for that commission of violation after violation after violation. I strongly encourage landlords that every time there is a violation of the lease to issue a written notice to their tenant indicating that a violation has been committed and that repeated violation might lead to eventual termination of that lease. In fact, the best way to do this is to have a discussion with the tenant well in advance of any violation. Specifically, I recommend that landlords have a talk with their tenants before the lease is ever signed, before keys are ever handed over, before a deposit and first month's rent are ever accepted from the tenant, that it's explained to the tenant that any violation of the lease will be met with a notice of default. So what should be in a notice of default? Clearly, you should indicate to the tenant what has gone wrong. They either did something or failed to do something they were required to do per the lease agreement. And so you're pointing this out, and generally you're giving your tenant a reasonable opportunity to cure this default. Let me give you an example. So let's say the default has to do with cutting the grass, and the tenant is required to maintain the lawn and cut the grass, say, every 2 weeks. But it's been 4 weeks and the tenant simply has not done it. You're getting calls from your HOA or letters or calls from your neighbor saying, what's going on with the red house over here? That grass hasn't been cut in a while. So what do? You send a notice in writing to your tenant saying you are required under the terms of your lease to maintain the yard. In fact, if there's a section number or a provision in your lease that you can point to explicitly, I would remind the tenant of that provision in your written notice of default and let them know I'm going to give you a reasonable amount of time, and then tell them what that amount of time is. 3 days, 5 days, 7 days to fix the problem. And if they don't fix the problem, you have the choice to either go and do it yourself and then probably charge them the requisite fees for that, or issue a new notice and say, if I have to do this myself, or if I have to do this again, you'll be met with a notice to vacate and a termination of this lease. But you want your notice to be very clear why you are issuing a notice and what is expected from that tenant. Generally speaking, a good tenant is going to receive this and fix the problem, and you may never see this problem again. But a bad tenant will continually violate the lease, and that's an indication to you probably need to move on. Now, another common notice that you should always deliver in writing is a notice of rent increase. Now, this isn't available in the middle of a lease term, but once your lease has lapsed into a month-to-month tenancy, at least in the state of Texas, and generally across the US and various states, you can increase the rent. Again, in certain states, you've got certain limits. Those limits don't exist in the state of Texas, but with a notice to the tenant, you can increase the rent if you are on a month-to-month tenancy, as long as you give enough time for that increase to take place. Now, the amount of time is going to vary, but it's largely going to depend on what is already in your lease. If notice of termination of a particular part of your lease, including the lease entirely, is 30, 45, 60 days, you have to honor that if you're also going to attempt to increase the rent. If you live in a jurisdiction where your lease can be increased with a notice that you send to your tenant, then make sure you follow both the rules of that jurisdiction, but also the rules in your own lease. For example, you don't want to send a notice that the rent will increase in 30 days if your lease requires 60 days of advance notice of termination. If that's the case, well, then you haven't technically terminated the prior term and your move is not technically legal. Make sure that you understand what your state says about the ability to increase the rent after an original term has ended, and the amount of time that's required based on your jurisdiction and the terms of your lease. Next is your notice of termination or notice of non-renewal. Whatever you call it, it's not super important, but it's important to know when you need a notice of termination or a notice of non-renewal. Your lease may have a definitive end date that doesn't require any additional notice. In fact, your lease may not have an automatic lapse into a month-to-month tenancy by agreement. That may simply not be part of your lease. It is understood that the lease starts at date X and ends at date Y without any notice needed. However, many leases have an automatic renewal provision, and the only way to stop an automatic renewal would be for one side, landlord, or the other side, the tenant, to give an adequate notice, letting the other side know, I have no intention of renewing this lease either for a year or a month or any amount of time. This lease will end at this time. So it's important for both landlords and tenants to really understand how the notice of termination operates, because many people get this provision very, very wrong. If, for example, a lease says, in order to terminate this lease, either the landlord or the tenant must give a 30-day advance notice to the other party. That doesn't mean that it's any 30 days in the lease. It specifically means at least 30 days from the end of the lease in order for the notice to be effective. Let me give you an example. Let's say a party signs a lease on January 1st of the year, and the lease ends on December 31st of that same year. And they enter into this agreement, move in, and then sometime in the middle of June decide, you know what, I think I'd like to move somewhere else. I'm gonna give my landlord a 30-day notice. Well, that notice wouldn't be proper because although there's at least 30 days there, the effective date isn't, again, any 30 days. The first day this would become effective would be after December 31st of that year or January 1st of the following year. That lease is locked in until the end of the year. So it's not technically a 30-day notice if you give it in the middle of June. It's more like 175 days of notice because the effective date is the very last day of the lease. And it's important that both tenants and landlords understand how this provision in their lease works. Otherwise, you don't have a 12-month lease. If you could at any time with 30-day notice simply terminate, that's a month-to-month lease. And if your agreement is from January 1st to December 31st or whatever combination of months you have, that last date, that date of termination is the last day of the lease. And you must give 30 days of advance notice from that date. And if you don't, the lease automatically renews for another 30 days or whatever the provision says in your lease. Generally speaking, it's a 30-day renewal from month to month thereafter. Make sure you understand how this works so that you, the landlord, are not simply accepting a random 30-day notice from a tenant who insists that by giving you this notice, even in the middle of the lease, they're entitled to leave after 30 days. That simply isn't true. However, you may find yourself in a position where you want to do something different with your property. Maybe you want to sell, maybe you want to move into the property. Maybe you want grandma to move in because of whatever reason. If you're in a state where you can simply terminate a lease on this basis, and you don't need some other basis to end a tenancy, then you're going to have to give notice to your tenant well in advance, but definitely within the time limits required under your state law and under the terms of your lease. Make sure that you are cognizant of both of those numbers, especially if they vary. But generally speaking, a notice of 30 days is going to be what most states are going to require, and your lease probably mentions 30 days. If it doesn't, make sure it's at least 30 days, because it could be more. As long as your notice gives at least that amount of time, it should be proper. Now understand that there is a difference between a notice of termination and a notice to vacate. We're going to get to the notice to vacate yet, but there is a distinct difference. And I want to point out that difference right now. A notice of termination says at some time in the future, the lease will come to an end. This does not mean that the tenant is presently in violation in any way of the lease. It's simply telling the tenant at some future date, the lease will end. Understand that in most cases, when you're sending a notice of termination, there is no violation to speak of. The tenant hasn't done anything wrong necessarily. The lease is simply coming to an end. Again, if you live in a state where cause is required before you can terminate a lease, make sure that you have proper cause before you are sending that notice, and that you indicate in that notice that you do have proper cause. In the state of Texas, no such cause is required, and so as a lease comes to an end, a landlord can send a notice of termination or a notice of non-renewal to simply bring the matter to an end so that they can use the property in some different way thereafter. So your last notice to consider is that notice to vacate. And what I recommend to landlords is that they have a set criteria when they issue a notice to vacate. I have a philosophy that a landlord should issue a notice to vacate after 3 violations that have nothing to do with rent, 3 non-rent violations, or after 7 days in a given rent period when 100% of the rent or any fees owed at the time have simply not been collected from the tenant. I tell landlords that if you have a single non-rent lease violation, it may not be enough for a court to agree that there's sufficient cause for an eviction. Now, if you have a truly egregious violation, maybe they intentionally set fire to the garage, or they're conducting some illegal activity. I don't think you need 3 separate violations of any of these incidents to demand possession. But if you have smaller violations that could easily be cured, generally speaking, courts don't like evicting for non-rent violations. Again, that can easily be cured with notice. However, if a tenant has multiple violations over time and simply either continues to do the same thing over and over and over again, or never fixes the thing that you've given them notice of, now you have a stronger argument that they have lost their right to possession and that you can demand possession from them. So the easiest way for you to prove this to a court is with, evidence, photographs, invoices, even communication. But the strongest is that pile of notices of default that we spoke about earlier. Do you have a set of notices that you have served on the tenant to no avail? You served them, you waited, you gave an adequate amount of time for them to fix the thing, and they simply won't do it. Well, at that point, I would say you have cause to issue a notice to vacate, which is that unconditional you got to get out of here notice to your tenant. Now, different states are going to require different amounts of time and different provisions or different content in their notices. I'm not going to get into all of that, except to say that in the state of Texas, you can generally, and many states allow this, issue a 3-day notice to vacate. There are some instances where longer notice is required. If that's you, you're going to want to know that before you ever send out the notice to make sure that your notice is procedurally adequate. But assuming that you have the right number of days in your notice, then it's a matter of proper delivery of that notice. Again, different jurisdictions have different requirements for delivery. We send all of ours through regular and certified mail. And so if that works for you, I strongly encourage it because it's an easy way to prove that you sent your notice to your tenant. You want your notice both to adhere to the law of your local jurisdiction, but also have a proper basis. Of course, the gold standard is non-payment of rent. If your tenant isn't paying the rent, then they gotta go. And generally speaking, non-payment of rent is the strongest basis for terminating a residential lease. I tend to advise 7 days. If by day 7 you have not received 100% of the rent and all of the fees that are owed by that date, you probably have a strong cause of action for an eviction, and that's probably the time you should be issuing notice. Now, some landlords say, nope, by day 4, I'm issuing that 3-day notice to vacate. And there's technically nothing wrong with that so long as that's available in your jurisdiction. I'm not saying that doing it any sooner is wrong, but doing it much later than day 7, unless your jurisdiction requires it, doing it much later than day 7 could be problematic for you for a number of reasons. Statistically, once a tenant gets to day 7 and they haven't paid the full amount of rent, there's a high likelihood that the following month's rent will be impacted, that either it will not be paid on time or will not be paid in full. All you're doing is kicking the can down the road by not issuing the notice to vacate in the present month. We also know that the eviction process takes a significant amount of time. Different jurisdictions, again, are going to take longer, but in Texas, we know that it's about a 30 to 45 day process, and because of that, it helps you to get started sooner rather than later. Because we also know the following: good tenants who, for them, this is a one-time thing that'll never happen again, are going to fix the problem within that 30 to 40 day time frame. But tenants who simply aren't a good fit, who simply can't afford the tenancy anymore, or who are constantly violating the lease, are not going to get things resolved within that 30 to 45 day time period. So giving extra time doesn't really help in those situations. All it does is create more loss for you and create more problems. Now, for those of you who are just starting out or maybe just don't have a whole lot of experience with the eviction process, I have an offer for you that we are making available to all of our clients during the month of October, particularly for those in Texas. If you have rental property in the state of Texas and are issuing notices or would like to learn a better way to issue notices and file evictions and even handle eviction appeals in the state of Texas, then you may want to check out our eviction course. There's a link in the description below, but you can also check out attorneyeg.com/EV for more information on that eviction course. We walk you through the process of your notices, of filing, and even the kinds of things that you can expect at trial and on appeal. If you would like a course where we go step by step from notice to judgment to help you recover your property faster, I strongly encourage you to check out attorneyeg.com/EV, our Texas eviction course from start to finish. Again, I'm going to walk you through multiple modules. I give you samples of your notices, samples of an eviction petition, and plenty of resources along with my step-by-step training to help you file your own eviction with success. If you need more information, feel free to send us an email at info@attorneyeg.com and check us out at attorneyeg.com/EV for information on our Texas eviction course. Getting notices right is a crucial part of your landlording business. notice. If you're simply not sending enough notice or not sending notice at all, I strongly encourage you to get into the habit of issuing written notice and delivering those notices in accordance with your jurisdiction. I hope you found today's video helpful, and for additional content, feel free to check out the rest of our library of videos on this channel. YouTube seems to think that this particular video is the next best thing for you. Check it out and everything else we have to offer. And until next time, landlords, happy leasing.